Any mention?
Your Lordship,
Yes.
I beg to mention item number 11. Your Lordship, kindly let this matter come after 1 week, Your Lordship.
Yes. Who is the other side? Item 11?
No objection, Lordship.
Yes. The request made on behalf of the petitioner. When do you want it?
After 1 week, Your Lordship.
After 1 week.
Yes, Your Lordship.
List this matter after 1 week.
Right, Your Lordship.
Yes.
May it please your Lordship. Lordship, I beg to mention item number 13. Your Lordship, item number 13. Your Lordship,
Yes.
the matter is pending before DB. Kindly grant 2 weeks of time.
Okay. Yes.
Yes, my lord. No objection, my lord.
We'll have it after 3 weeks.
2 weeks.
Yes,
2 weeks. Is there any purpose to distinct after 2 weeks, or will there be? We'll have it after 3 weeks, sir. Yes. On the request of the petitioner, list after 3 weeks. Yes.
Highly obliged.
Please, Your Lordship.
Yes, Your Lordship. Your Lordship, I beg to mention item number 20 and 21. Lordship, in this matter, I paid for 2 weeks' time.
You are appearing on behalf of
Respondent 2, Your Lordship.
person number 2,
Yes, Your Lordship.
20 and 21.
Yes, Your Lordship.
Yes.
Connected matters, Lordship. Quashing.
No objection.
No objection. 2 weeks, Lordship.
Yes. On the request made on behalf of
Right, Your Lordship.
for the state respondents. On request made on behalf
Obliged.
of the state respond number. What is the respond number?
She's for 2.
Respondent number
You are
2, Your
asking for time, isn't it?
Yes, Your Lordship.
Yes. In both the cases, you are respond number 2.
Lordship. Yes, Your Lordship.
Same person.
On prayer made on behalf of the respond number 2. List after 2 weeks. Yes.
Obliged. Please, Your Lordship. Lordship, I beg to make a mention for item 4. Lordship, Lordship, I'm praying for a week's accommodation, Your Lordship.
Item 4.
Lordship.
Yes. No objection. This one prayer made on behalf of the petitioner. Not objected to the Legality Council appearing for the state respondents. This is matter after 2 weeks.
1 week, Your Lordship.
After 2 weeks. Yes.
Highly obliged, Your Lordship.
May I please, Your Lordship, I beg to mention item 17.
Yes.
I pray for 3 weeks' time, Your Lordship. I pray for 3 weeks' time, Your Lordship. Sir, Paske is there. Video.
Yes, Mr. Paske.
I'm appearing for the sole respondent.
So
Your Lordship.
respondent, Your Lordship.
Any objection? No.
No objection, Your Lordship.
Yes. Yes, sir. This is also on request of the petitioner. List after 3 weeks. Yes.
Much obliged, Your Lordship.
Deeply obliged, Your
Yeah.
Lordship.
Your Lordship, I beg to mention item number 6, Your Lordship.
Number 6.
I pray for 2 weeks' time, Your Lordship. The senior counsel is on a sanctioned leave, Your Lordship.
No objection, Lordship.
Just on the point of the petitioner, not object to the Legality Council of the respondents. List after 2 weeks. Yes.
Similar prayer for item number 12 and 15, Your Lordship.
Who is appearing 12? The other side.
12, 15, we are appearing. 12 is Union of India, Lordship.
Yes. Union of India. Where is 12? Nobody is there. Here for you.
Union.
Okay. 12 and
15, 15, Your Lordship.
15, no objection.
no, 15 will just say on request made on behalf of the London Senior Counsel appearing for the appellant. List this matter after 2 weeks.
Obliged.
Much obliged, Your Lordship.
12 also will just say on the request made on behalf of the London Senior Counsel appearing with the petitioner. List this matter after 2 weeks. Yes.
Please, Your Lordship, I beg to mention item number 19, Your Lordship.
Yes.
Lordship, I pray for 2 weeks' time in this matter.
For the private respondent, 3 weeks will be allowed, Lordship, because the Legality Council will be available on the last week of June. 3 weeks.
So 3 weeks. Okay, we'll have it after 3 weeks.
Respondent number 1, Your Lordship. Respondent.
Just record the appearance and just say on request made on behalf of the petitioner. List after 3 weeks. Yes.
Obliged.
Lordship, I beg to mention item number 18, Lordship.
Yes.
I'm praying for 2 weeks' time, Lordship, in this matter.
No objection, Lordship.
Objection. Yes. You are appearing for?
I'm for respondent number 5, Lordship.
Okay. Items. Are the request the petitioner? List after 2 weeks. Yes.
Obliged, Lord.
May I please, Lord?
Yes.
My Lord, I beg to mention item number 7 and 8, my Lord.
7 and
8 requires some
connected
recommendation.
matters.
My Lord, a week's time.
No objection, Lordship.
A week's time will do. No, do not ask time for just purpose of asking again later. Just if you say like 1 week time will. You want 1 week or 2 weeks?
2 weeks.
2 weeks. 7 and 8 on the request of the petitioner. Not objected to by the Learning Council for the respondents. List after 2 weeks. Yes.
Highly obliged.
Obliged, Lordship.
May I please, Your Lordship? I beg to mention item number 14, Your Lordship.
Yes.
I pray for 2 weeks' time, Your Lordship.
No objection, Lordship.
Weeks on the request of the petitioner. 14. Yes.
Highly obliged, Your Lordship.
Yes.
May it please your Lordship. Lordship, I beg to make a mention of item 5, Lordship.
Item 5. Yes.
No
I'm
objection.
for the respondent, Lordship, in this matter. Praying for 2 weeks' time.
You are appearing for all, there is only one respondent?
There's only one respondent, Lordship.
No objection. Just on the request made on the respondents, not objected to by the Learning Council for the petitioner. List after 2 weeks. Yes.
Highly obliged, Lordship.
Supplementary cost list, item number 1.
Yes.
May it please your Lordship. My Lord, the petitioner before your Lordship, my Lord, was appointed on 2017, as in 2017, my Lord, as a casual employee by the respondent, this council, my Lord. My Lord, that appointment is, your Lordship will find at Annexure 1, my Lord. Annexure 1, my Lord, with a fixed pay of 5,000 rupees, my Lord. Page 11, my Lord.
Yes.
Casual, as casual, in a fixed pay of 5,000 rupees, my Lord. My Lord, thereafter being appointed, the petitioner joined her duty and has served as a casual employee for a period of 7 years, my Lord, without any break, my Lord. Thereafter, my Lord, by Annexure 3, if your Lordship come at page 13,
Yes.
she was regularized to the post of peon, my Lord, with a pay scale, my Lord, of 17,000-41,000.
What is her name?
Her name is reflected at number 2, my Lord. Serial number 2.
Okay.
Serial number 2, my Lord. Annexure
Even regularized as a peon.
Peon, as a peon,
Yes.
my Lord. My Lord, she had joined her post and was performing her duty to the then thereafter, my Lord, after joining her duty, my Lord, write Annexure 5, if your Lordship come at page 18, my Lord. No complaint, nothing, my Lord.
Yes.
Subsequently, my Lord, by Annexure 5, page 18, my Lord,
Yes.
her appointment has been revoked and she has been reversed back to her earlier post as casual employee, my Lord. Annexure 5, page 18, my Lord.
Just a minute. Just let us come back to the Annexure 3, page 13.
My Lord.
That is done in January, 3rd January 2025.
This is January, 3rd January, my Lord,
And
2025, my Lord. Immediately on 30th May 2025, that order has been revoked.
yes.
And my Lord, she has been reversed back as a casual employee, my Lord. So, my Lord, without any show cause notice, without any opportunity to be heard, my Lord, and in in violation of the principle of natural justice and, my lord, the service jurisprudence, my lord, I have been reverted back to the post as a casual employee, my lord. My lord will see that the post which I have been appointed as peon, my lord, this regular pay scale has been given on that, my lord. So, my lord, as a matter of equity, my lord, at least show cause notice should have been given to me, my lord, before reverting me back to as a casual employee, my lord. So that is the case of the petitioner, my lord.
The limited issue.
My lord.
Violation of principle of natural
Violation of principle of natural justice, my lord.
Yes.
Your Lordship, principles of natural justice would have arisen if these were regular appointments. In fact, not only the petitioner here, in a series of cases. Now, all these are irregular appointments. Why I say irregular, my lord, is because firstly, there is no sanction post. For making an appointment, firstly, there should be a sanction post. And secondly, as per Article 14 and otherwise also as per the rules of the Council, any appointment should be by way of recruitment. The rules are there, very clear.
There has to be a selection process.
Selection process, which has never been done. All along, it would appear, right from 2017, she was appointed as casual. We don't dispute that fact. But regularization by itself is not a mode of appointment. You cannot claim that you have.
But then it's a conferment of benefit. Well, may not be a mode of appointment.
Yes.
Now, once you confer benefit, rightly or wrongly, is it not that when you take it back, you give him an opportunity?
Well, decisions are there. Once these appointments are irregular appointments, the question of show cause will not arise.
You see, like what is regular, what is irregular? Is it not that we have to decide it by taking into consideration the factual aspects of the matter?
Well, this is not only one case.
Have you given the reason that they were at least
Yes.
whether your
My Lord,
order?
if your Lordship will see the Annexure 18, page 18,
Yes.
Annexure 5. Consequent upon the decision of the Executive Committee, KHADC, the regularization of Shri So-and-so as peon is hereby revoked as the same has been done, dehorsed the applicable.
But that is a general statement. You do not say the specific issue.
They have not mentioned
There
any-
may be
one
many
of these
aspects.
rules.
If you refer to the rule in general, there may be many aspects in the rule. It did not specifically say that it was done without any
My Lord,
selection process.
I'll just draw your Lordship's attention to the rules.
See, you may have. We can understand one thing
Yes.
is that yes, so far as the question of the petitioner's appointment and the legality is concerned, may be difficult in the past so far as there is no selection process.
That's why, my
But
Lord.
in manner which you have taken away the benefit, and that is what you should have provided the opportunity. Well,
My Lord, I will satisfy your Lordship that in case of irregular appointments, the question of natural justice will not come into play.
My lord, the
Because it would be a futile exercise.
now, how do you say it is irregular and regular?
Irregular because firstly, my Lord, these are not sanction posts. There is no sanction post.
How do you know that it's?
There are no sanction posts.
But then your termination order or your reversion order doesn't say that this were not sanctioned posts. Doesn't say so. You say dehorse rules.
Yes.
Now, what is that dehorse rules?
They will be against the rules. My Lord, I'll show the rules.
Your rule is not confined to one issue, isn't it?
Yes.
It speaks about many things. So, what is that thing? At least they should have they must know what for they are. That is what.
My Lord, my submission, my answer to that, it would have been a futile exercise because this has not been done only in respect of the petitioner.
Even the
This decision was a policy decision taken by the Executive Committee.
See, rightly or wrongly, you confer him certainly benefit. At least your order doesn't say that the benefit was extended for certain period of time. So, once you confer, at least some vested right is created. If you take it away again, saying that yes, it was not lawfully conferred, then at least you have to give him focus. At least an opportunity to be heard. That is what is needed.
That is the only what is left.
So that is what.
Let me file an
response.
affidavit within 1 week, my Lord, and these matters can be heard finally, because it involves a lot of money. My Lord will have to also take into consideration that there are
See,
around.
what this code basically wants to confirm is that the opportunities are provided to them, nothing.
But
Anyway,
I would have to satisfy this court. Suppose even if we issue a show cause notice, it would be an exercise in futility.
Maybe.
Maybe,
law
but then
mandates
if you see it.
I will satisfy your lordship that the law also does not mandate that a show cause notice is
we
necessary.
cannot prejudge a issue by, you see, like anticipating what would be the outcome. A patient would die doesn't mean that he should not be provided treatment. So that is something. If something is to be provided, you should provide.
My lord, what we are trying to do, we have nothing as against the petitioner. I mean personally, we are trying to streamline.
At least make them know what for.
Yes.
They may not be, since they are grade 4 staff, so may not be very educated and enlightened persons. Would not understand the basis on which public appointment is made. Okay, so at least they should know. You take them into service, convert them certainly, you see, and then suddenly you take it. At least tell them for what you are taking it.
Well, some of the petitioners have even taken loan, my lord, against this. They have taken loan also, my lord, the salary. Some of
That
them
also,
have,
you see, you do it at your own risk because you see, ignorance of law may not be,
my lord,
may not be always a good deal.
NOC has been given by the respondent themselves, my lord. The NOC for taking the loan, my lord, from the bank. It's not that I'm taking directly. Without the NOC from this council, my lord, I cannot
My
take a
lord
loan
will
of
see
them.
the records, how appointments are being made earlier on. On a piece of paper, an application is being made, and the then executive member or chief executive member, please appoint.
See, if you say so, if you say so,
Change of
then it
dismissal.
becomes very important on your part to allow them, give them a chance of opportunity. If you say that they have been, you see, like reverted back just because there is an illegality in the mode of appointment, then you must give them an opportunity.
My lord, I will satisfy your lordship. I have a decision of Supreme Court exactly on this
But then
issue.
you are saying that the manner in which appointment has been made. And we'll just see.
We will file our affidavit, my lord, within 1 week. I don't want to linger this matter also.
Okay.
Because it involves, my lord, nearly ₹1 crore every month to pay these employees, and we don't have that sort of money. That also has to be taken into consideration.
But
But
then
they are
we-
not sanctioned posts.
Was it not required for you to consider before you convert that benefit upon them? Anyway,
The less said, the better, my lord, before your lordship, how this was done. And we now, the present executive committee is trying to streamline all this, put things in order. That's why we have taken this extreme step. And plus, we have retained them as casual employees. We don't want them to suffer.
I just heard Mr. Interim Learned Counsel appearing for the petitioner. Issue notice returnable in?
Well,
Notice to be returnable by which date? Next week?
next week, my lord, I will file the affidavit within a week.
Okay, returnable in 1 week. Mr. T.T. Diemdo, Learned Senior Counsel, assisted by Mr. Sangma, FPS for the respondent number 3.
No respondents.
3, 1, 2, 3.
No further notice is called for. It is submitted by the Learned Senior Counsel that the counter affidavit in this matter would be filed within a period of filed before the returnable date, and matter can be disposed of on the next day fixed. So in view of the submissions made, this is matter for admission hearing
Next week, next
After-
Thursday, my lord.
after a week.
Next Thursday.
My lord, till then, the impugn order, my lord.
Yes. There is a prayer for interim thing.
Yes, my lord. This case has been filed, my
Oh,
lord.
there is a miscase
Interim
file.
would be difficult because the salary, again as I said, it involves money.
Well,
My lord, as on June, there is no provision. My lord, they can wait for a week.
No, but then if you have not given them the show cause, we'll just wait. If you say that it will be disposed of in the next week, then let us see then what happens.
If by next week we don't, it can't be disposed.
You have options also. Otherwise, you can withdraw from giving effect to these orders and pass fresh order after giving opportunity. So if you do not do that, then let us go legally. Yes, there is a miscase filed.
my lord, this case has been filed, my lord.
So you want this order to be passed in the miscase?
My lord,
In this case.
102.
hard, just say, same like before, Mr. So-and-so and so-and-so for the hard, Mr. So-and-so for the applicant, and London, Mr. So-and-so, London Senior Counsel, assisted by so-and-so for the respondent. Yes. Just paragraph. By this application, the applicant has prayed for stay of the impugned office ordered number 352 dated 30/05/2025, passed by the opposite party number 2, by which the applicant applicant's appointment as peon was revoked and he was reverted back as a casual employee. Stop. Give paragraph. Upon considering the submissions made by the rival parties, do not say upon, on hearing this, on hearing these submissions, made on behalf of the rival parties, and on perusal of record, it transpires that the petitioner was appointed. Petitioner was appointed as a casual employee. By office order number 580 dated 6/9/2017. You will find it at page 11, annexure 1 of the writ petition. Okay. Petition, applicant, do not say petitioner, applicant was appointed so and so. Okay. As a casual. Thereafter, the applicant just say after, do not say thereafter, after completing for about 8 years as a casual employee, the applicant was regularized as peon on the basis of the decision of the Executive Committee of the Khasi Hills Autonomous District Council. On 3rd January 2000. What you said? Just say. Just say the last line. Was appointed as. By office order date, by office order number 21 dated 3rd January 2025. You'll find it at page 13 of the writ petition. Stop. However, by impugned office order number 352 dated 30th May 2025, this is at page 18. Okay. The regularization of the applicant as peon was revoked, and he was reverted back as a casual employee.
Two batches. PO. In here, same. Only the post.
Come on, it appears that no opportunity was provided to the applicant before the decision to revoke his appointment as peon was made. There is also nothing in the record to show that the specific reason for which such a decision is taken against the applicant was ever made to the applicant. Okay, paragraph. Just in view of the above, it is deemed appropriate to suspend the operation of the impugned office order number 352 dated 35/2025 till the returnable date. Stop. And then just a list along with the main writ petition.
My lord, 1 to 18.
The same
matter, similar matter. Only difference is, my lord, the order office order number, the date
So
of.
then we have to take note of that. Otherwise, it will be a problem.
I'll
supply.
When he was appointed, when the casual appointment was made,
my lord,
when regularization was made,
my lord,
and when this reversion order was made.
my lord.
These three once it is given.
Yes, my lord. We will provide, my lord. We will provide a list, my lord.
You have to give because we have to pass
Yes,
the
my
order.
lord. We will provide a list, my lord. The date of appointment as casual employee, then regularization, then they are reverting back to the post of all the three years. We'll provide the list, my lord. 1 to 18, my lord.
You have a difficult case, probably.
My lord,
You have a difficult case, probably.
my lord, we'll try to.
Just
I'll
see,
try my level best,
that
my
is the
lord.
only thing. But then,
We'll try.
just
I'll
see.
try my level best, my lord. To
Otherwise, what the senior counsel says, because it's a public appointment.
my
Yes,
lord,
these are
I
public
can
appointments.
understand that.
Exactly, my lord. We don't want to punish them also. That is not our intention, my lord. Now, CAG also has come up with a report.
See, what happens, once you confer some benefit to somebody, and when you take it back, that becomes punishment.
Yes.
That becomes a punishment.
I
You may not
understand
have
very
the
well.
intention.
Yes.
Okay, but then that is ultimate.
Because we do one, we can't leave the rest also. We have to take a decision. It's for many people. We know that. What are the consequences? But at the same time, my lord, we are faced with such.
And you see, you are at liberty to do this thing, but then at least follow the whatever is needed.
Principles at least.
Like once you confer some benefit, it should not be taken away without at least giving them an opportunity.
I've done my studies on this, my lord, and Supreme Court is quite clear. When it comes to irregular appointments, they said because it becomes an exercise of futility. It becomes a mere futile exercise in the sense that the executive committee has already decided.
Now you take a stand and then make us know that what is your exact thing, because you
Yes.
only say that it is because dehorse rules.
My lord.
So dehorse rule means it can be many things, many aspects.
We will in our affidavit.
Much obliged.
Daily cause list, item number 1.
All matters, same order will be passed.
Yeah.
Yes, same process.
My lord.
Lordship, here the respondent number 5 have already received, Lordship, while the respondent number 6 is still awaiting, Lordship, service report. Lordship, for respondent number 5 will be filing our affidavit of service during the course of the day, Lordship.
The officer indicates that none has, the service report has not come.
Yes,
Now
for
you say
respondent
that
number
respondent number 5 has been served.
has received already.
On what basis you say?
Lordship,
You
here
filed
we
an
have-
affidavit.
Yes, Lordship, we will file during the course of the day, Lordship.
Okay, you will file during the course of
Yes,
the day.
Lordship.
So you have not filed.
Yes.
And what about 6?
Lordship. 6 has not received, Lordship.
So what is to be done
Still-
about 6?
Lordship, we may be allowed to take a fresh step again, Lordship.
What is the service report with regard to 6? What does it say?
Item has not been delivered, Lordship. We have checked.
What is the reason for not?
Lordship, there is some pin code mistake, Lordship, from our part. We may be allowed to correct and
No, you do one thing. First, you file an affidavit saying that 5 has been served and 6 has been not been served, and then we will allow you to take fresh steps on respondent number
okay,
6.
Lordship.
Okay. So let us move step by step.
Lordship.
Okay. Yes, the office note indicates that the service report. The office note indicates the report of service on respondent number 5 and 6 is still awaited. Stop. The petitioner shall verify. No, but then it is already, order is already there. You should have filed this affidavit.
Lordship. We'll
So
file
what is
during
the
course-
question of passing the same order again? Okay. In the affidavit, you are saying that 5 has been served and 6 has this thing. 6 has not been served.
Lordship, respondent 5 has already been served, Lordship.
In your affidavit, which you are like going to file today, are you saying that 5 has been served and 6
Yes,
has
yes.
not been served?
Lordship.
Okay. So you first file it and then we will pass the order.
Okay, Lordship.
Okay. Just do not write anything. Just the learned counsel for the petitioner submits that service affidavit pertaining to the respondent number 5 and 6 will be filed during the course of the day. In view of the submission, let this matter after a week. So let it come after a week and then we will pass it.
Lordship.
Yes.
Obliged, Lordship.
Item number 3.
May it please your lordship.
Yes.
Lordship, in spite of our best effort, your lordship, in spite of the best effort, your lordship, from our side, your lordship, we cannot obtain instruction, your lordship. Lordship,
Okay. So what is to be done?
lordship, may close this matter, your lordship. Lordship, may close this matter.
Well, I will close.
Lordship.
So shall we write that there is a prayer from you to close the matter?
Lordship.
There is no problem with that.
No, lordship.
Think over and just say it's all right.
Lordship, let it be withdrawn, your lordship. Let it be withdrawn.
On withdrawal, my lord, that's what is.
Okay, you will withdraw.
Lordship.
Say clearly, court must hear.
Lordship.
You will withdraw.
Lordship, let it be closed, your lordship.
What is meant by closed? Then we will dismiss. See, either we will dismiss for default or you withdraw it.
Dispose, your lordship. Dispose. Dismiss, your lordship.
Okay. So we'll just say, despite your best effort, you could not take instruction. Okay, is it all right?
Lordship.
You see, be clear. You must say, is it your contention that you have tried to obtain instruction, you did not get instruction? If it is that, then we will say that petitioner is not interested to pursue the matter, we will dismiss it for default.
Lordship.
Or you want it other way, that you want that we could not contact, let the matter stand withdrawn. Or what? So you want it to be this thing. Okay. We'll dismiss it for this. This the learned counsel, just record his name. Mr. So-and-so, learned counsel appearing for the petitioner submits that in spite of his best effort, he could not obtain necessary instruction from the petitioner. This is an instruction with regard to this case from the petitioner. Stop. He therefore submits that the court may pass order as deemed fit and proper.
Necessary order.
Okay.
In fact, my lord, this writ petition is relating to the removal of the signboards on the national highway on the state roads. So they were asked to give the details of the members of the association. The writ petition has been filed by the association. So when they were not able to clarify as to who are the members, whether they are still in existence, what purpose will be served if this writ petition is allowed, so they failed to get all
It is
the
a matter of
letters.
2017.
Yes,
It has died its natural death.
Died this
Only
natural
because
death.
of them that was kept alive.
Kept alive.
Okay. What we said before the last line. See, court may pass necessary order. He said this one so he could not be necessary. Okay, he just further submits that he has no instruction to argue the matter also. And then you say submits that court may pass necessary order. Okay, it is submitted that court may pass. And is submitted that the court may pass necessary order as deemed fit and proper. Okay. And on which date, Mr. Sangupta, it was ordered for taking instruction?
Lordship, order
There was
dated
no order passed.
1109, Your Lordship. 11/09/2023, Your Lordship.
11/09.
Yes, Lordship.
2023.
Lordship.
Okay. The so then just say Mr. Shangupta, learned additional senior GA appearing for the state response number 127.
I'm appearing for response number 127.
Yes, submits that. Since no instruction has been provided to the he just says that there is no real desire on the part of the petitioner to pursue this matter anymore, and the same may be dismissed for default. Give a paragraph. Give a paragraph. Just say a perusal of the order sheet of this case reveals that by order dated 11/9/2023, the counsel appear for the petitioner was granted time to obtain instruction as to whether there remained any cause of action surviving in the matter. Stop. From the side date, till today, no instruction could be obtained by the Lord Counsel appearing for the petition. Stop. It appears that the petitioner has no real desire to pursue this case. Accordingly, this writ petition stands dismissed for default. Stop. You are appearing for? Just record his name also. You were not there at the time when the court started passing order, isn't it? It's all right, no problem. I just dismissed it. There's nothing will happen to you. You will just lessen the burden of the court. Because nothing survives actually, and if you see these different annexures, this contract for utilization of these hoardings expired long back. That is what.
Item number 9.
Yes, Mr. Gautam.
Well, it's
May it please your Lordship. Lordship, learned senior counsel is on legs before courtroom number 2. Lordship, I pray that the matter be listed at the end of board.
At the end of the board, how many matters are there in between?
just two questions were raised, my lord, on the last occasion, and the records were called for, of course, because the records were not before the court. My contention was that, my lord, my post-confirmation was not properly dealt with. It was signed by somebody, it was dealt with by somebody who did not have the right to deal with it.
Yes.
And the other thing was dropping of witness. So today records are here, my lord, and
My lord, I am required to produce the records, my lord, where the DGBSF signed in the office notice, my lord. But that
and whether the listed witness was examined or not.
My lord, mainly
there are two aspects.
On the first aspect, my lord, because the order is signed by the law officer, my lord.
Yes.
So whether this is an order of DG or not, so my lord, that is in Delhi. I have written to them, my lord, because other records are with me, my lord. But that file, because it was in headquarters, my lord, I am praying for 2 weeks' time, my lord.
Well, it's that preposition, while it has been signed by somebody. The question of seeking instructions, whether it was signed by him or not, does not arise.
No, but the
no, signature is in office noting.
Records are here, my lord. Records are very much here.
117 records are in Delhi, my lord, in the headquarters.
Well, it's my
court martial was conducted here, my lord. That record is with me. But that 117 proceedings, there's a separate file.
That will be vital. See, let us see if that things goes in your favor.
Absolutely.
Then
only thing, my lord, I am in custody for such a long period of time, served more than half my sentence, my lord. And my lord, lordship was pleased to allow me to go on bail on 2 occasions, my lord. I did not flout the conditions. I came back.
This is this case.
This case, my lord.
His father
yes, my lord.
passed away and all. Anyway, then just
2 weeks time, my lord, I'll place it positive.
My lord, if they are not able to place it, then my lord, my miscase may at least be heard. And my lord, if the records can be kept of the court, my lord, I'll also peruse the records once.
No, if they do not see, like here in the midst of the final hearing, if they fail to produce the record, then we'll draw adverse inference.
2 weeks time, I'll try to get it.
And the records which they have produced today, maybe
kept
in court.
That will help the court. If these are the prime issues.
Yes.
Definitely.
Yes.
What about his other contention about this non-examination of the
very vital witness?
Dropping witness.
Have you checked the thing? You verify that aspect also.
I'll address on that also on next time.
So, my lord, what I was suggesting, my lord, if the records can be kept in court, like in all other matters, because, my lord, on the last occasion when records were called, we were only allowed to peruse the records once, my lord.
Record was called for perusal, not for retention. That is.
So, I may be allowed to peruse the record once too, my lord, because on the last occasion I was given a very small.
Argue the matter, my lord, on next date. The records are with me, my lord, we will place it.
And there will be
but what is the anxiety of allowing me to go through the records or placing the records in the court, my lord? Lordship, it is before the High Court. And not allowing a counsel to go through the records.
That, my lord. If it is, if
Dr.
it is
Majika,
necessary, my lord.
one thing is that if you do not have any objection, you can allow him to sit here also. You can
Yes,
please
I mean,
take
one
your
of his,
junior, give it to your junior and let them examine the record. At least let them sit for at least half an hour, 1 hour, and Mr. Gautam may offer your junior a good cup of tea also.
They have all the papers, my lord. The entire compilation is here, my lord. It's their compilation.
my lord, everything was.
I have nothing to hide, my lord. I'll place it.
So, but then what is the harm if they compare with this?
Before
Record is not something like case diary that where they do not have a right to go through.
one day before, my lord.
The record is of my trial. I have every right to peruse, my lord.
So, what is the problem if you sees it today only?
Today is not here. These are records.
I'll just take half an hour's time, my lord. I'll not take much time.
Let's call it.
You record. You allow them to inspect. You just detain your officers for some times and then let it be this.
Before next
Do you
hearing.
want some judicial order to be passed for this thing, or you will do it? If you say that this thing, we are not passing any order.
My lord, order be passed, my lord. We can do it today. I mean, I wanted to inspect the orders today. Well, since the record is here, I can do it today. Because if I do it on the next date.
See, if Dr. Majika says that you will be, you will be allowed to do that, that is good enough. We do not have to pass any order. This will be understanding, you see, on good
Senior
understanding.
counsel is submitting, I understand.
My lord, no judicial order is required, my lord.
Okay.
My lord, today may not be possible, but between tomorrow and next day, we will fix a date, my lord, when he wants to inspect. I'll bring the record, he can examine that.
I'm okay with it.
Today it will not be possible.
But today, because...
Okay. Yes.
But no order is required, my lord.
Yes.
There is understanding.
Yes. Mr. Dr. Mojika, London DSGA submits that in terms of the order dated 23/5/2025, he has received only one part of the record and the other part would be produced within a period of
2 weeks.
2 weeks. He prays for grant of some time for the production of the entire record. Stop. Mr. Gautam, Learned Counsel appealing for the petitioner, has no objection to the grant of time. Stop. However, the Learned Counsel submits that he should be allowed to inspect the record which has already been received by the office of the Learned DSGA. The Learned DSGA has no objection to the inspection of the record by the Learned Counsel for the petitioner. Stop. In the above situation, the Learned Counsel for the petitioner shall coordinate with the office of the Learned DSGA
Order required.
and fix a time
Well, this order may not be
required.
May not be required, my lord. We will do our level, my lord.
Since seniors submitted, I am okay, my lord.
That is all right. You see, like if you say that, then second part of the last part, after this thing, prays for grant of some time, then you say prayer allowed, list after 2 weeks. And then second part, where we say that, where he submitted that record being allowed, this is not required, delete it.
Not, I'll show it to him.
Do it.
Well, we'll do it.
Much
Let us have a, you see, like a gentleman affair. So if it's normally something like that, at least this court doesn't appreciate that thing between the counsels when one assert one thing and the other deny. And that is in relation to their own activity, personal activity.
My lord.
not in relation with the conduct of the client. So that is something this court doesn't have to. You see, this is very bad. It lowers image of the lawyer before the court. It should not happen.
No, we don't have any such thing.
Especially the lawyer of, you see, like the counsels of your standing, your status. It should not happen.
No, my lord, we have a very good relationship.
Sometimes it happens, you will find that there is a assertion by one thing and the denial by the other. And that is with regard to their personal exchange of records or maybe documents and all. It doesn't go well.
My lord.
Anyway.
Much obliged.
Allow him, let him take all the defense. He is a convict. You should give him all the opportunities.
Yes, ma'am. Absolutely no problem. We'll sort it. We'll give ample time, my lord.
Much obliged.
Item 10.
You can pass so many orders because in those matters, the motion, all matters you have to file separate orders. So alone managing, you do not know. Yes, Dr. Modi, do you intend, Mr. Jha, do you intend to take up the matter and finish the hearing today?
My lord, it will take some time.
Okay, so the thing is that the court is also left with one the main PS is on leave.
So, my lord,
we cannot know because there will be perhaps if there are so many orders, because of the motion there are so many orders. Even if we complete the hearing also, whether we can
pass the order.
Finish passing or not. Anyway, if there is any short things you want to point out, you can do that. See, you are ready for hearing otherwise.
Yes.
But then we can hear and make it reserve also if you want. Councils are ready then.
But there is no such urgency, otherwise it can be taken up any next week sometime also. He's out from service for quite some time, my lord.
So you want to give him out for some more time? Or as much as possible? That is in relation
This is a dispute
to
with regard to domicile certificate, my lord. He was recruited because in paramilitary forces, my lord, when the recruitment rally is done, so for example, there are 100 posts of riflemen, my lord. So posts are allocated to the states, my lord. Lots of seen the advertisement is in
local reservations are there.
State-wise reservation. For Maharashtra, maybe 5 seats, for UP, like that, my lord. He applied against the quota of West Bengal, my lord.
West Bengal.
West Bengal, giving a domicile certificate from West Bengal, some south district, my lord. Now later on it transpired that that certificate was not genuine, my lord.
He got the job. He was selected.
He was selected.
And he was appointed also.
My lord, he has served 8 years. And based on my lord, a purported complaint, my lord.
Okay. So
based on a purported complaint, my lord.
Some complaint came from
my lord. However, the Court of Inquiry initiated in August 2016, prior to receipt of the complaint, my lord.
That is, but then what is the problem if department has its own information?
My lord,
basing on which they initiated.
My lord, based on the complaint. The stand of the department is based on a complaint.
So, okay. So, and according to you, that complaint was not in existence.
Not in existence.
And then what happens to the core issue? That the certificate.
Certificate, my lord.
It was a manufactured document.
My lord, it says
it was a forged.
No, it does not. The report given by the authority concerned, it says it does not relate to this office. Does not say that it's fake. Okay. And even the Court of Inquiry procedure, my lord, the finding of a Court of Inquiry, my lord, that also does not say that it's a fake, my lord.
What does it say then?
It does not relate to the office.
I will just, if the file is before Lordship, page 31 of Lordship kindly says, my lord.
Page 31.
Of the writ petition, my lord.
Yes.
Government of West Bengal, my lord. Office of the Sub-Divisional Officer. My lord, kindly see the spelling itself, my lord. Southwest, Pragna.
You are referring to page?
Page 31 of the writ petition, my lord.
Yes, this is
Government of West Bengal, my lord.
Yes, that is a report by the Government of West Bengal. Written to
the
presiding officer, Assam Rifles. To
My
you.
lord, my lord.
One page before that, my lord.
Oh, yes. Page 30 then. 30.
It's not numbered in my copy. This is a 2010, my lord. This is the certificate he produced at the time of recruitment, my lord.
This is, just a minute. This is his re-verification of domicile certificate. Page 30.
After that, my lord. In the page
After that, next page is the communication
report of the
by the Government of West Bengal to your officers.
My copy, there's another page in between.
That is a problem again there. Mr. Jha, you should take care of all these things. If there is that becomes a serious problem while appreciating matter, you see. Now see, Dr. Mojika, the page 28, annexure 1 is the convening order. Is it that?
My lord, that is correct, my lord.
There is
Page 29 is confidential written on top, my lord.
Page 29 confidential, and then anyway it was overlapped by seal.
Page 30 is letter dated 21 September 2016.
Yes, re-verification of domicile certificate. Is it okay? Now is it this what you are referring now?
No, my lord, there is another page after that.
Yes. Next page is the letter. This is the
report of the
communication by the
This is the
Government of West
report
Bengal.
South Pragna is there. Here your copy. This one. This one. 20 April 2010.
See, as per record, page 31 is dated 27/9/2016.
He is numbered in his copy page 30-A, my lord. But in court copy it seems it is not there.
Please verify, Mr.
My lord, I will.
Just see it now, right now. Just see it. There is no 30A. From 30 it is 31.
Mr. Jha's copy is there, my copy also is there.
He has a special copy for himself.
For me also.
Mr. Jha,
My lord, I will.
we will have this matter on other day. Meanwhile, you will just correct it, verify and correct it. This is a problem, you see, like person assisting you must take note of these things. You should do. And this appears to be very common nowadays. Dr. Mojika, you were trying to point out to what actually?
My lord, actually I have this copy, my lord. Extra copy, I'll just pass on.
This is a...
Actually, this is the domicile certificate on the basis of which he got appointed, my lord. This is dated 24. What I was trying to point out, my lord, kindly see Government of West Bengal spelling is correct, my lord. Office of the Sub-Divisional Officer. And then, my lord, kindly see Southwest, Pragna.
Pragna.
Now, I found out from website, my lord, of the Government of Government of West Bengal, there is no such Southwest Pragna subdivision, my lord.
See, this may be a letterhead which was in use in 2010. Now, this is how do you verify that what was the letterhead at that moment of time?
Well,
if we are to make an,
because Southwest Pragna, there is no district, my lord.
we can understand.
West Bengal till today, my lord.
We can understand that, but then you will find there are many departments where this printing work is outsourced, given to private parties, and when it is submitted, it comes like that. Even the court has experienced it with some department, and it happens.
Now, below, lordship will see. On top is Southwest Pragna, my lord. Below, my lord, where the signature is there, Subdivisional Officer, only Pragna, my lord.
Pragna. There appears to be anyway, but then the main thing remains is that, you see, like in manner which we have come to the conclusion that this is not the original one.
No, my lord, that is the next page in the writ petition, my lord. We verified from the office from that office, whichever, because there is no such office.
That is the 27/9/2016.
My lord.
And here it has been clearly stated that doesn't relate to that office, isn't it?
And my lord, kindly see the spelling of Pargana, so, because this is, we know, my lord, from childhood, South 24 Pargana is a district, North 24 Pargana is a district. Or Pargana spelling is very
Yes,
different.
it appears totally, and there it is in the clarification thing. It's South 24 Parganas. Their seal, their spelling, everything is all right.
And who has done this, my lord, he also is totally carelessly is done.
Even your certificate also doesn't say you are resident of 24 Parganas. It is 24 Pragana.
South 24 Pargana, my lord.
Even see the content also.
My lord.
Mr. So and so, son, daughter of so and so, village so and so, PS so and so, in the district of South 24 Pragana.
And on top there is no South 24 also, my lord. And where signature is there, South is also not there, 24 is also not there.
And this appears to be. So this certificate is not enclosed in the writ petition.
In my copy is given.
It is.
Yes, in which place here in this writ petition?
Page 30A, my lord.
My lord, it's there in the petition, my lord.
Okay.
Wait, let me we'll just see, just a minute. Just find out. What is the ground taken in the writ petition? Ground of challenge? The principal ground?
Violation of 183.
What is that 183? 183 of which act?
No opportunity to.
Is it? No opportunity was given.
Yes, my lord. It was the court of inquiry was done in the absence of the.
Okay. Is it correct? Dr.
Socus notice
Mojiga?
was given to him, my lord. He is replied to Socus notice.
And what about that? There is no, his participation is not needed in the court of inquiry.
My lord, it is on the basis of.
Whether the.
Because court of inquiry is only fact finding, my lord. Now after that, my
Whether,
lord, on prima facie satisfaction, my lord, there is something wrong here. We issue the Socus notice,
Then,
he gives a reply.
Then at what stage the incumbent gets an opportunity to defend himself?
One Socus notice was issued to him, my lord.
That is the only opportunity. So after Socos, so far is the proceedings before the court of inquiry is concerned, the
Court of inquiry is only sort of investigation, my lord.
you can understand that, but then if that investigation report is sought to be relied upon for taking a decision detrimental to the interest of the petitioner, in such a case, whether he deserves an opportunity or not.
Of Socos, my lord. Opposite of
To
Socos was given.
defend himself. We do not know. That he will clarify what the law provides. The purpose is that he should get an opportunity to defend.
My lord, we have given him the finding of the court of inquiry, my lord, opinion of the staff court of inquiry, recommendation of the DIG, along
And
with the
then is there any opportunity for him to challenge the finding of the court of inquiry?
No.
Whether
anything contemplated
the
in
court of inquiry is something like a sort of preliminary inquiry at our end, my lord. So whatever our finding, we gave it to him along with the Socos notice that these are the finding of court of inquiry. What do you have to see? And in reply, what
It's
is
not there. Yes, you have to enclose it.
My lord,
If that be the thing, if that is a part of this thing. Anyway, we'll just see. And then, yes, please, Dr. Mojiga, please continue. Then just make this court to understand the basic law with respect to which you move. Now, court of inquiry.
My lord.
Now, what do? You first give an shock cause notice and then you hold a court of inquiry.
No, my lord. Court of inquiry.
On what basis you formulate an allegation and then you give him opportunity to oppose?
My lord, supposing a complaint has come, my lord, so we hold an in-house inquiry, but that is called court of inquiry. Court word is a little confusing sometimes, my lord, but it is basically an inquiry, internal inquiry.
One and the same.
My lord.
Yes.
So once that inquiry says that there is a prima facie some material, so along with the copy of that inquiry report, and there is some recommendation on that. So along with all this complete set of papers, along with the shock cause notice was issued to him that these are the findings what you have to see.
So a shock cause is called for only after the court of inquiry comes to a prima facie finding that yes, the matter needs to be taken.
And he replied to that.
Then he files an shock cause. And then what happens? Then what do you do with the shock cause?
But then order is passed, my lord.
Now, who takes into consideration the shock cause and who decides it?
But in this case, DIG has passed this order, my lord.
What, as per the law, who does it?
DIG is a competent authority. Under the
where it is provided?
Section 11.2
11 of the
11.2 of the Assam Act. And Section 183.8 provides that when the military reputation of a person is at military reputation of a person.
What is meant by military reputation?
My lord, that means allegation against the petitioner or any person. He, throughout the court of inquiry, he has to be present. None of the witnesses has to be examined in his absence.
Okay.
So he has to given a liberty to cross-examine the.
Meaning thereby that if everything is to be done in his presence. So means the day for holding inquiry has to be informed.
My lord.
So you say that there nothing of that such was done in this matter.
My lord. No proper opportunity
you
of
have taken that specific plea in your writ petition.
My lord.
And what is their reply to that in the affidavit of opposition?
They specifically they did not say para 25 of their affidavit. They casually said that all the rules and regulation has been followed.
Okay, that is a short answer.
My lord.
Say that we have complied with all the rules.
All the rules and regulations.
There is no specific statement as to on which date you were given opportunity, or which date you have been given notice and when you defaulted and all. Nothing.
Even the complainant was not examined, my lord.
Anyway, let us see if you say like this. See, if there is allegation of manipulation of certain document, maybe absence of complainant would not make the case.
My lord, that may be
weaker or may not weaker.
My lord, that may be even apart from the court of inquiry, my lord, the complainant might have. Till what prompted, what debarred them not to annex the copy of the complaint, which they have specifically said that the complaint was given at the PMO office, my lord, on such and such date. Nothing is on the record, my lord. Even not in the court, show cause notice.
It's only on procedurality, my lord. But in substance, the fact he has not been able to say or establish that this is a genuine certificate.
See, source of information may not be very important. Certain issue. Only thing is that whether you have been provided with adequate opportunity
of. Even my lord.
First of all, apart from the principle of natural justice, the opportunity is created by the relevant rules. So whether that has been afforded.
And even there was a recommendation for after the show cause notice, my lord, reply of the show cause notice, for an additional court of inquiry. When I have said that I have not been given.
Whether it must be held or it is something optional.
No,
depending on the situation.
No, my lord. When the DIG himself says that additional court of inquiry whereby he should be given a proper opportunity, that was not done. I have annexed in my rejoinder.
Rejoinder, you cannot make out a fresh case. Anyway, but then what about your certificate? What you will do? If it is not this thing and if it is...
But it is there in my affidavit.
It is not there in the court's copy.
In my affidavit, I have annexed the same document.
In the court's copy, it is not there.
No, but in my affidavit also, this document is there.
It's available. In our copy, it
In the
is.
writ
Actually, it
petition
is in your court copy. It is available.
Well.
In your thing.
Page
So it is
33
okay. So there may not be any need to bring it on record by him. And it's
I
okay.
think-
There is no problem. If you say so, then we will move that way.
No, my lord, I'm only saying, but he should rectify the record, my lord.
But then it is not
Court
important
record should
what
be
you are
rectified.
holding. It is important what the court is having with you.
Well,
So that certificate will not be treated as a part of the writ petition.
that is difficult.
That may be treated as a part of the affidavit in opposition which you file.
But,
I
but
think,
before
my
next
lord,
date, if you can rectify the record, my lord, that will.
It's up to him. If he thinks that is vital, he should do it. Otherwise, we may ignore if it is not that
My lord, I think additional
relevant.
affidavit.
But then only thing is that the problem will be that when you refer to the pages, to the particular annexures, there will be difficulty in that.
I think, my lord, additional affidavit bringing on record the.
You can make it, which is already on record. What is the purpose of bringing it on record? Dr. Majika has said
My
already
lord,
that he's been talking.
even from our side, I have filed
Only
that.
thing is that how do we reconcile with the page numbers and all? That is the main problem. So,
But how can he insert also a page now? That's the.
that is something should have been done. You see, like the party's copy and the court's copy must tally. If it doesn't, then it becomes a problem. Now we cannot make it tally now, since the pages have already been arranged and it appears that it is missing. So the only way, basically, was to bring it by separate affidavit. But then since we have already brought it into the record, so not it. Anyway, so what shall we do now then?
My
lord, I will-
continue hearing next statement after a week or whenever he wants.
You come equipped with law, Mr. Jha, and make sure the submission which you make
My lord.
is established by
The law.
placing the relevant laws. Otherwise, this court may not go into the minor things, okay, and like an appellate authority will not come to
Definitely
the factual appreciation of the matter, will not re-appreciate these things. Only we will see the procedure safeguard, procedural safeguard,
Which has been deprived of.
whether those where you have been deprived of those things. We'll just say on, we'll just say on request made by the parties. On request made by the parties, this is matter after, next week, how is the thing? After 2 weeks, next week they'll be having to us.
And after some hearing, my lord.
Hmm?
After some hearing, my lord.
Okay.
Because
Okay, we'll just.
that makes difference for me, my lord.
Because effective hearing, my lord.
Okay. Maybe after add the just add Mr. Arjun on counsel for the petitioner. You see, problem is that when one is counsel and another is senior counsel, you cannot say the hard line counsel paying the parties. The senior counsel may say that I have not been given recognition. by the-
Recognition in the.
So that is what this court doesn't want. So just say Mr. Arjal Anand counsel was the petitioner, and also Dr. Majika Laureate, GSGI, assisted by Sogra or the respondents. Assisted by MS Sogra. Yes, sir. Let's pray for this is matter after 2 weeks for further hearing.
Item 16.
Please, Your Lordship, the learned additional advocate general is on next before the division bench.
What
If
is
the
to be
matter
done?
be taken up,
Come this way. You are not the respondent. You are the petitioner here. State is the petitioner here.
Your Lordship, if the matter may be taken up at the second half or another date may be given.
The additional AG is ready to do it the second half.
Yes, Your Lordship.
Now, if you say second half, how many cases we have apart from this? We have some more matter. So if you say so, and then if the court comes back, court will come back specifically for this matter, and then thereafter whatever the reason, court will not allow adjournment. So whatever you pray, make responsibility.
Your Lordship, another date then.
We'll have it, next week also we have busy schedule, we'll have it after 2 weeks.
Much obliged.
On prayer made on behalf of the petitioner. Wait, allow the court to complete the order.
My
The
apologies,
council
Your
must have some manners, you must know.
My apologies.
Before court completes passing order, you are not supposed to move from here.
My apologies.
After just you complete your prayer, you leave, that is not the, this is just on prayer made on behalf of Mr. K. Khan, learned PP, appearing for the petitioner. This is matter of 2 weeks. Yes.
Much obliged.